Chief Holloway is the chief of police of the St. Petersburg, Florida Police Department. He has also worked in the Boston area, and the chief is very involved in a number of organizations dedicated to reform in the police arena. He serves and chairs various committees, but he also works collaboratively and I guess intersectionally with other constituent entities in the law enforcement area. He co-chaired the American Bar Association Criminal Justice Section's project on the use of body cameras, and he works diligently with the law enforcement committee of the Criminal Justice Section, and that is Chief Anthony Holloway. There's much more about him, but he will share some of that with you in the course of his presentation. Let me next introduce to you the Honorable Tracy Todd, who is an elected judge. She's on the 10th Judicial Circuit Court of Alabama, sitting in Birmingham, Alabama. Judge Todd currently chairs the Judicial Education Committee in the Birmingham area. She's brought about many educational programs in the area of racial justice, in terms of ethics, and in diversity and inclusion. She has been a fellow of the Criminal Justice Section and currently co-chairs or chairs a number of committees in the section. She's one of our young leaders. Judge Todd spent a good bit of time in her area of education in Japan, so she speaks fluent Japanese. She has a master's degree from Duke University School of Law, and is, as I said, a leader in the criminal justice area and a leader in the judiciary. Next, I am Judge Bernice Donald. I am a past chair of the Criminal Justice Section, and I've been involved in the American Bar Association for a number of years. I sit currently on the 6th Circuit Court of Appeals for the United States, and I served as a district court judge for a number of years, and I was an elected judge like Judge Todd, but I was elected to a limited jurisdiction court. And I wanted to show you this picture because as we talk today, I'm going to be talking about diversity and inclusion, and I'm going to have a thing to say about diversity. This was my staff about 5 years ago, so I wanted to show you what the absence of diversity looks like. Normally when we look at the absence of diversity, we're looking at a group that is all white, and I wanted to show you that the absence of diversity can be any group where there is no diversity in that group. Go to the next slide, Kevin. Today, I want to start by making a couple of introductory remarks. As we know, the 14th Amendment embodies a guarantee to all citizens the equal protection under law. Our jurisprudence has established equal protection, equal treatment, and equal opportunity as hallmarks of our system. But on the ground and in the lived experiences of people, we find that some people are less equal than others, and some people are correspondingly more equal than others. And this is manifested in various groups as we look at our pluralistic society. In the criminal justice system, what is really the criminal legal system, there are a number of disproportionalities that are manifested, and this has particular impetus in the gap between, certainly the gap between blacks and whites. The US criminal justice system is the largest in the world, with approximately 7 million people who are under the protection or supervision or being held by federal, state, and local jails and prisons. And many people are under the supervision through probation and parole. We find that more than 5.2 million people, or 5.3 million people, pardon me, in the US cannot vote as a result of convictions in the criminal legal system. This broad statistic masks oftentimes the racial disparity that is manifested in the criminal justice system amongst African Americans especially. In a 2018 report to the United Nations, that report found that African Americans are more likely than whites to be arrested. Once arrested, they are more likely to be convicted. Once convicted, they are more likely to experience lengthy prison sentences. African Americans, according to the report, are 6 times more likely than whites to be incarcerated, and Hispanics are more than 3 times likely to be incarcerated than their white counterparts. The Sentencing Commission, which collects data on these groups, reports that American Indian youth are 3 times more likely than their white counterparts to be held in juvenile detention. There are similar statistics that break it out amongst African Americans and Hispanic youth also. But today we're talking about how the unequal treatment affects the rule of law. So we're going to talk about this amongst our 3 panelists, and I want to start out by asking Chief Holloway. Chief Holloway, if you would, talk a little bit about your experiences as a police chief. You obviously are an African-American male. You are tasked with the responsibility of protecting and serving, and we know that the actuality of justice can often be different than the perception, but both matter. So could you talk a little bit about how this plays out where you are and what you do to enhance this fairness that the 14th Amendment prescribes, and how you push back against these perceptions of unequal treatment under the law? Chief Holloway?
Thank you very much. Thank you very much, Judge Donald. Thank you for inviting me here today and talking about this very, very tough topic. First of all, I am the Chief of Police in St. Petersburg Police Department. Our police department has over 575 employees, sworn, and over 200 civilian employees. And as you can see, our budget is about $119 million. The population in St. Pete is about 265,000 people. So the question that the Judge Donald asked me, I have to really start back with the history. So that's how we got to the point where we are now. So first, the officers always taught about the 9 principles by Sir Robert Peel. And what he talked about back then was saying that whether a police department is effective or not is not by the number of arrests they make, but about the life of crime. And we forget that because we're all driven by the numbers, and how do we get to those numbers? We have to remember that we police by consent of our community. So I've been doing this job for 35 years. So I'll start how we got to where we are and how we need to continue to change the thing that we're headed into, a trajectory. So back in 1985, a lot of you may not be aware of it, that's when crack cocaine hit our low income communities, our African American communities. So everybody was up in arms trying to figure out how are we going to get this issue out of the community. So in 1991, they started another program that was sponsored by the federal government called Weed and Seed. And basically that grant was to weed out the bad element and seed in the good elements. Well, every police department was trained to go in and just take down everybody they saw in the community. Everybody was perceived in the Black community as possibly a drug dealer, or they were committing a crime. And I gotta admit, I was part of those teams too, because I was a sergeant in charge of it. As a lieutenant, we put officers in there, but every time we created a unit, we put those units in the African American community. So the only thing people saw was those officers come into the community, take someone to jail and leave, and that was the last time they saw them until they came back in as a group. Well, I'll say law enforcement did an excellent job at doing the weeding part of it, but we forgot to do the seeding part. We forgot to work with the community, because from every generation after that, all we taught those officers were, so let's go into an African American community, let's go find someone selling drugs, and let's take someone to jail. And that was it. We didn't police the whole community that way. We just went right into those low income communities. And we were targeting violent crime, drug trafficking, and drug-related offense in those communities. But again, we didn't really ask the community what they needed. We were telling the community what they needed. So now it's time for us to start taking the seeding part of it. And that's where we are now. And that's how we're gonna have to change this. And the change comes through culture. That's through me, other police departments, law enforcement agency, judicial system, and the community as a whole. Is how are we going to change that? So my first police chief job, I took in a town called Somerville, Massachusetts in 2007. And the mayor hired me in Somerville to bring in community policing because he had heard what we had done in Clearwater, my old agency. And that job was really to get out back in the streets and to start meeting people. And we said the 3 E's: evaluate, educate, and then do enforcement. Because that's the only way you're gonna learn. Instead of just having officers go into a community and come back out. One analogy I use is people, when they see a fire truck, the first thing they think of is someone trying to help them, someone trying to help their family. When you see a police officer's vehicle, the first thing you think is who's going to jail, who did something wrong, and that vehicle is not here to help. So we want to change that philosophy. So when I got my first job as a chief, we started a program called Park, Walk, and Talk. It's very simple. You're going to park your car, you're going to walk, and you're going to talk to people in the community. They're no longer going to see you as a person that's coming in their community, taking someone to jail, but they're going to see you as a part of that. So I did that in Somerville, Massachusetts. Then I was hired to be the chief in Clearwater. I did the same thing. And now I'm here at St. Pete Police Department. And we've done the same thing. And people say, well, how did that work really? And remember, I'll go back to what I said about from Sir Robert Peel, about it's not how many numbers of arrests you make, but it's how safe the community is. So the first year I came here, our tips that we received from the community was 247 tips from the community. Now we receive over 2,600 tips a year from the community because the officers are getting out and talking to people in the cars because they want the same thing you want. They don't want the drug dealers there, they don't want the crime there, but they don't want to see you as someone that's occupying their community. Then we started talking about how do we do justice reform? And I want to thank the American Bar Association because we said, no one said we could do it. Well, 2020 proved everybody wrong. March of this year, when COVID-19 happened, guess what? Every police chief, every police sheriff figured out how to do justice reform. We figured out we didn't have to arrest everybody for every misdemeanor. We figured out we didn't have to put all our units in one area to patrol. So it's there. And then the last thing that happened this year, we all witnessed the killing of Mr. George Parrott Floyd. And that really made everyone think about how they were doing policing, what type of training they need to be done. And we say, you know what, we have to stop. And there's an analogy that I always use also. We have to stop fishing with a fishing net and start fishing with a fishing pole to go back to strategize. You don't need to take everyone down in the community, but you need to take that one person that everybody wants out of the community. We also have to stop using implied bias or using our bias because maybe there's one person in that community is doing something wrong, but it's not the whole community. And you need to know those other 99% of the community. In return, the community, that's because one officer does something wrong, doesn't affect the whole police department. So it's that communication in both ways. So I'm going to end with this, is that we're saying that now you need to rethink, retrain, and rebuild in the community. And that's on both sides. Thank you.
So you mentioned George Floyd. So I want to, and you mentioned the Park, Walk, and Talk program, but I want you to expand a little bit because, you know, we know that communities of color need police as much, if not more, than any other community. But they also want and need a police department that is going to protect and serve, that is going to respect, that is going to address them and recognize their humanity. And I know you said we have to build back. For those communities that are not as advanced along their reforms as you, what do you say to them? And then I want to go to Judge Todd, because I know that she has police officers in her, or has had police officers in her family. And there are many communities that are different than St. Pete. So, but what do you tell people? What are the practical tools you give them on what they can do to sort of rebuild that trust and answer the community's questions that says, why can't I get a law enforcement unit that is going to protect and serve, and not one that's just going to come in and beat us down?
Well, let's start with that again, like going back to that park walk and talk, getting out of your car and getting to know that person, because most of the officers that patrol in a community, the only people they know about in that community is the people that they're answering that 911 call. So this picture is getting out of your car and getting to know Miss Jones, Mr. Smith, Mr. Rodriguez, because they're people just like you are. In that toolbox, if you only come to the toolbox with a hammer, then you see everything as a nail. Bring some other tools. That first tool is that communication part of it. It can be done. You have to want to do it. Just as you walk in a lower income neighborhood, I can tell you the same thing. If you walk in a high income neighborhood, they perceive police officers the same way. As soon as they see a police car in their neighborhood, the first thing is, what's going on? What happened? Because that's the only time they see an officer is in time of trouble. So if you get out and you communicate, and it's easy to do, you just got to learn how to talk to people.
Okay. Judge Todd, before I come to you with a question about how do we sort of militate against that unequal treatment or the perception of unequal treatment by the courts, did you want to comment at all on any of the police work and procedure that Chief Holloway talked about? Okay, you're muted. You're muted, Judge. Okay.
Sorry about that. Thank
Okay.
you, Judge, and thank you, Chief, for allowing me to be on this panel with you, and thank you, CGS, for putting on this topic. I want to say that as a sitting judge in the trial court who focuses on criminal work, I do come in contact with police officers on a regular basis. As a former prosecutor, I have come in contact with police officers on a regular basis. And I say to Chief Holloway, the work he's doing around park, walk, and talk is critical. I think that is where it is important for the community to feel connected to their law enforcement officers. And I think that's also what is important to help once they come into the court system is once people have that initial positive contact with police, once they come into our courts, they feel more aware of or feel more value in terms of procedural fairness. And that is what is something that's very important to me as a sitting judge. And so what police officers do out in the field affects how people perceive the entire process. It is important for people under the umbrella of procedural fairness to feel that they have a voice, that the court and that the police officers are neutral in the process, and that they are respected. And so the programming that Chief Holloway has put in place really sets the stage for people to come in feeling those three core tenets of procedural fairness once they get into court, which makes my job easier in terms of not only me being fair as an individual judge, but people perceiving the process to be fair, that they perceive that they have been respected throughout, that they perceive that the players and decision makers are neutral in the process. And so I can appreciate the tenets and the components of Chief Holloway's park, walk, and talk. And I believe that if they are implemented effectively, could be a help to those of us who are sitting at the end of the process, if you will, in the courts.
Okay, well, and I want to stay in this area for just a moment, but Judge Todd, and I know you want to say more about procedural fairness, but all too often, when citizens walk into courtrooms across the country, especially in the criminal arena, many of them feel like, and maybe some defense attorneys feel this way also, they feel like it's us against them. They see the judge, the prosecutor, and the police officer all being on the same team. And so it's that unified team with different components that is against them. The National Conference of Christians and Jews more than 5 decades ago did a survey, and they asked 4 groups, do you believe that you can reasonably expect to have a fair outcome in court, be it civil or criminal? African Americans overwhelmingly said no, can't get a fair shake. Right behind that were Latinas. Asian Americans were next. Native Americans were not surveyed. Whites overwhelmingly said, we believe we can get a fair shake in court, whether it's civil or criminal. What can courts and others do to emphasize the neutrality of the judicial officer, and that we're not part of a team, that the judge is there to sort of balance that fulcrum?
Well, that is a wonderful question, Judge. One thing that we as judges can do is first, we need to look at the practices that we implement in our courtrooms. I'll give you an anecdote of when I came on the bench and what I did as a prosecutor. In my jurisdiction, it had been a practice, and this is not to disparage any practices or traditions that had gone on, but this is the reality that I was involved in. As a prosecutor, I stood next to the judge's bench when I read the indictments. As a prosecutor, I would give out plea offers in the judge's chambers. As a prosecutor, I had freedom to come and go out of judge's chambers as I liked. The officers, when they came to testify, would come in through judge's chambers and then come to the bench from the judge's chambers. And so as a prosecutor, I really never thought about how that looked. I never thought about how someone on the other side may have felt about that. And quite frankly, as a prosecutor, I probably wasn't concerned just because of the position that I held. But once I came to the bench and I realized my role as a neutral decision maker in the process, I started to look at those practices and say, how does that defendant feel coming in, seeing law enforcement coming out of my chambers? How does the defendant's family see or feel seeing the prosecutor come and go out of chambers? And so I put a stop to that practice. And that was something that I did to send a message to not just defendants, but community observers, to victims, to prosecutors, as well as defense counsel, that I'm on no one's team. My chambers is not a part of your office. I'm not an extension of your office. This is not your waiting area. And so I hoped by doing that sort of change in tradition and practice, that I was sending the message that I am neutral and the court is neutral, and I want to treat everyone the same. Prosecutor, you stand at your table when you speak. Defense counsel, stand at your table when you speak. You know, the bench is kind of off limits to anyone else other than those who are coming to testify, et cetera. So we as judges need to look at what are some of the practices that we are doing? What are communications that we're having with police officers in open court? Do we seem chummy? Do we seem overly acquainted with people? We have to remember that people are watching us to see, and any perceived impropriety, if you will, or too much of a personal relationship can say to people, I'm not being treated fairly. So we have to look at that as judges and make sure we're not participating in those sorts of practices.
I know we have some judges in the audience and some prosecutors. You mentioned how we interact with other people, either coming before us or other members of the system. And I think, obviously I agree with you. I think it's critically important because I have seen situations, and I guess I was more cognizant of it than you because I was never a prosecutor. I was a defense attorney. And I could see sometimes obvious differences that the judge would oftentimes smile at the prosecutor and be very relaxed. And then you could see them sort of tense up or start to frown when the defense gets ready to make that presentation. And I envision, and maybe I wrongly perceived this, but in instances, it felt to me like the judge put on an air of disbelief when I got ready to either put my client's position forward or my client got ready to state that. And I think those are things that people very much see, because this is an environment that we're in each and every day. We know it, but for some people, it's foreign. And now there are those who've been there a few times, and so they're very comfortable with that environment and they know what to expect. But some people are coming in And we have to be sensitive to that. And I take that from your procedural fairness comments. And I know you had something else you were going to say about this whole process.
Well, and I wanted to really go into a question for Chief Holloway with my next kind of set of comments.
Please do.
Speaking about police officers and the treatment of people in the criminal justice system, you know, one of the things that's so important, as well as not only the first or initial contact with police officers at the outset of any sort of event or in the park walk and talk initiative, is how police officers present once they're in court. And I think that, and I want Chief, if you can speak to this, you know, I think it's really important and also weighs in on how people feel as if they're being treated unfairly or fairly when police officers, or depending on how police officers appear in court. Do they appear prepared, or that they've taken an interest in really investigating the case? Or was this kind of a cookie cutter, check the box kind of investigation, and they come to court and sometimes they fumble, don't know what they're really talking about, or can't remember the case, or seem kind of unconcerned, as opposed to those officers who appear well prepared, have taken the time to really talk to all of the witnesses involved in the case. What do you think about that level of interaction with people and police when it comes to the courts, about how people feel they're being treated when an officer appears in court and presents a case, especially for those victims who are of color, who may feel like their cases are not as important as others based on the police officer's presentation in court?
And that's a great question. So I would say I would go high, 98% of your officers, they present well in court because they take every case serious. And those other 2% that you see in court that don't really take it, and that's what people see, and that's what the victims hear. Like, he or she just treated me like something else. I live in the community. They really don't care about what happened to me. They don't care what happened to my family. But yet, when it's someone else, a person of wealth or someone of a different status, look how many detectives were there. Look how many forensic people were there. And look how they follow up with that case. It's like you're getting two different types of cases there. You get a lot of police officers to make an arrest in an African-American community, but you get a lot of detectives to follow up with a victim from another community. And that's why you got to try to keep them both equal, because that's what they see. You know, why there's so many detectives out at this location, but yet in my community, I don't see a detective. I just see someone going to jail. So you have to try to tell everybody to present the same way.
And Chief, let me, I know that Judge Todd wants to say something else, but do you feel, and this may be unfair, and you can not answer it if you like, but do you feel that when your officers walk in, that they have sort of instant credibility, more so than the average Joe citizen, even though everybody's taking the same oath? Do you feel like your officers have sort of added credibility by virtue of having the station, the status as police officer?
No, a long time ago, I would tell you, yes, people believe what an officer had to say. Now is you better bring a camera and have 2 other witnesses if you're a police officer, because we lost that trust. We did. Because of the way that some of the officers treated people in community. So again, we have to go back and rebuild that, because I used to, again, dating myself, I could come to the court, raise my hand, and probably get any search warrant that I needed because the trust was there, and other officers had that trust. Now, a lot of officers have misused that.
And I will tell you that many citizens believe that because we're all a part of the same club, that even if a judicial officer catches an officer intentionally falsifying information or whatever, that there are no consequences, that there are only consequences for, for the John Q. citizen or the poor defendant. I'll share with you an anecdote that when I was on the federal trial court, I had a case where a gentleman was being tried on a crack cocaine charge, and the officer came to court and testified that pursuant to a search warrant, they entered a home. They found a crack cocaine residue in the microwave, and that they sent it for testing, and that it came back positive for that. And, you know, I listened to this, and because the officer had been sworn to take an oath. When we got to and this officer was cross-examined by a really good defense attorney. And when the defense attorney got ready to present his case, he brought in the toxicology officer who testified that it was not crack cocaine, that information had been sent to the officer, and the officer had knowingly given this false testimony in at least 2 other proceedings. That was here in Memphis. I was aghast because the toxicology officer herself said, you know, he had this information when he testified at the preliminary hearing, when he testified at in the trial there. So in that instance, there was direct evidence. And so I referred that officer to the U.S. Attorney's Office for their disposition, however they did that. But, you know, it's important to believe that there are consequences with anybody who comes into court and knowingly gives false testimony, if in fact we're able to show that that is false testimony. I'll go back to you, Judge Todd, because you wanted to say something else as you set up the chief with that question. But I just wanted to make sure people understood that nobody gets a pass. There is no club, and everybody is held accountable for their conduct, I hope.
Well, I did want to say something else, but you also gave me another thought by saying that, and I want to pose another question to the chief in that same vein. I, as a judge, have been asked to sign warrants for shootings that involve police officers, whether they shot or shot a citizen. And in those situations, in one situation in particular, I was asked to sign a warrant where in the same department was investigating an officer from within the department that did the shooting. What are your thoughts about independent investigations for officers who commit the sort of acts that we saw in the George Floyd case, where we know that is going through the courts, but within your own department? What are your thoughts about your officers being investigated from within? Or what do you think about policies where it's automatically investigated by others? And do you think that one policy or the other policy helps to kind of encourage a trust in the departments across the country?
So I'll answer both questions. So first, for Judge Donald, her question is, if an officer lies in court, and I tell my recruits that first thing there, you're fired. I don't care what happened, because once you lie, you lie. You're no good to me, no good to people in the community, because every time you go on that witness stand, the first question a good defense attorney is going to ask you, have you ever lied under oath before? You got 2 ways to answer that. If you say yes, the jury's going to stop listening to you because now everything's going to be thrown out. If you say no, then you're lying again. So our policy at my department, if you lie under oath or lie to me, I will fire you just on that alone. Here in Pinellas County, we have changed that. What you're saying, Judge Todd, is to build trust. We used to investigate our own officers. Now we have an independent person come in, which is the sheriff's office, which I think is much better, because now you're getting that second opinion. You're getting that second look. So the sheriff and the state attorney's office will look at the criminal part of it, and the police department, we will look at the policy part of it. So you may have been correct criminally wise, but now we're going to see that you violate any of our policies. Mm-hmm. And that's how you build trust. You got 2 independent people looking at an incident.
Okay. So I'll come back to Judge Todd in a little bit, but I want to talk about the role that I think, or at least just touch on the role that implicit bias plays in the justice system. And I know we are dealing with explicit and implicit bias, but there is a question that has come in that I want to pose to the panel from our question and answer function. This question is, what can one do when one sees overcharging against the poor and minorities? What can be done to preclude this mistreatment within the criminal justice system? Many times the judge's hands are tied by mandatory sentencing and guideline issues. So it seems like the person has kind of answered the question, but I do want to ask us to at least to reflect on this and opine on it. And if there are any, if there's any advice you can give to the questioner, please at this point impart that.
Oh, I'll go first. It's up to the police chief and the sheriff. If you have things in place, you should not be stacking charge. I'll use the possession of cocaine, resisting arrest, and you just keep adding on, adding on, adding on. Find the highest charge that person with that charge. If the other charge is part of your probable cause, then yes. But no one should be coming out with 5 and 6 charges off of just a possession of cocaine.
Mm-hmm. Okay, and I will say to the caller that I'm going to give an example in the end of my presentation where I will show you, and I'll talk about what I did there. So I'll go to Judge Todd now.
And I'll say that prosecutorial discretion overrides a lot of what we as trial judges can do in terms of what charges are presented to us, because they are not our charges. It is the discretion of the prosecutor what they bring in. However, I do think that we as judges have a role in making sure that justice is implemented equally. And I will give another anecdote about that. I had an instance where a white male defendant was charged with assaulting his wife. Police were called. She sustained injuries. When the police came in to try to administer aid to her, he shot at the police. He was charged with domestic violence assault, shooting at the police, I think assault on the police officers, some pretty hefty charges. When we got to court, the prosecutor asked that the charges be reduced, that the assault on the police officers be dismissed, and that he be given probation. And I was very curious about that because I wanted to know in what world had prosecutors recommended probation for someone who shot at the police. That was a new one for me. Not that people shoot at the police often, but that was just a very interesting offer. And I questioned the prosecutor about it, and they gave me their reasoning. 2 weeks or so later, maybe 3 weeks, a young lady appeared in front of me for making a terrorist threat against the officers, wherein she said and used some foul language with the police officers, threatening to kill them. Well, when she got to court, the offer was for her to plead as she was charged with, as the chief said, a couple of stacked charges, and for her to go to prison. She had no criminal history and had not done anything other than offend the officers with her verbal assault on them, if you will. I found that to be a very disturbing set of circumstances where we had such just disparate sentences being recommended for people who did things that were so divergent in terms of their severity. And so as a judge, I felt it was my duty to make sure that this young lady was not being treated differently from the man that appeared in front of me. So as judges, I think we do have a role in that. And I think that the police perhaps, and Chief, you can answer this, about how the police can help us to avoid those sorts of circumstances coming in, because the prosecutors oftentimes rely a lot on your recommendation when coming to court and making sentences. They often speak with the police officers and will not make certain recommendations in some cases without clearing it with the police. So what are your thoughts about police, the police influence on sentencing recommendations?
I think the officers should have some input on it, but they should also come with a package, so to speak, the criminal history, not just because a person is a person of color, but really stating this is why this person needs to be charged with this, because this is their history, their criminal history that you can look at. Just because they are a person of color, they shouldn't get a higher sentence than that. And that's why we asked a question to you, Judge Todd, the same thing, because as we're doing these conversations, people in the community, they see a person of color gets one charge and a white person gets another charge. So they even say, hey, Chief, I got arrested for 3 pieces of crack cocaine. I'm looking at 3 years. This guy got caught with trafficking in powder cocaine, and he's looking at probation. So is there a difference? Because I'm being treated totally different.
Yeah, that's valid. One of the comments that's come in and questions that's come into the question and A box says, isn't funding of the department sometimes linked to the operation of the police department and the prosecutor's office? Don't you receive more staff based on the number of cases, charges filed, etc.? Is this a basis for total unfairness? And does it lead to discriminatory practices against the poor and minorities? Either one of you can comment.
Well, I can speak for Florida. We hear that all the time. So I always start with the first one is people think about traffic citation. Here in Florida, there's actually a state statute. We do not make money off of tickets. Basically, I think I get $4.32 off of every ticket that's written in the state of Florida. The rest goes toward the court system. And again, it doesn't matter how many arrests we make. My budget stays the same. So it's not based upon the arrest. It's based upon what you're doing in the community.
Okay. Well, I just want to comment that, you know, the criminal justice section has an implicit bias initiative that cuts across lots of things. And this is not an implicit bias seminar, but I will say that this does play a role. There is an ubiquitous association between Black and crime. And if anybody has taken the IAT test, the implicit association test, and there have been many researchers who have worked in this area, and they find that there is that association. Dr. Jennifer Eberhard, who's with Stanford, she's a researcher, and she's written a book called Bias. And she talks about how that association happens very early in life, and it happens across the board. It's not limited to one race or one socioeconomic group, but it's sort of across the board. And we get these influences from every area of our life. I want to just read something, and this is a comment from Justice Ginsburg in one of her opinions back in 1995. She said that it's not a criminal case, but she said that that the existing disadvantages, excuse me, of African Americans and the long history of legal and social measures designed to maintain, quote, white supremacy, affect our systems throughout. She argued that certain structural racial hierarchies must be dismantled before minorities can enjoy the equality of opportunity, true equality of opportunity, pardon me. She reflected on the persistence of racial inequity. She said that bias, both conscious and unconscious, and the unexamined habits of thought keep up barriers that must come down if equal opportunity and non-discrimination are ever genuinely to become true and become a part of this country's law and practice. And we get these things from our lived experiences, from the culture, popular and otherwise, from media, and this seeps into our practices at everything we do. And I want Kevin to put up a slide right now to talk about this association of Blackness and crime. And this is a media structure. These slides come from a New Orleans, Louisiana newspaper. And this happened in the immediate aftermath of Hurricane Katrina. And you'll see in the slide with one image, it reads, a young man walks through chest-deep floodwater after looting a grocery store in New Orleans, Louisiana. Now we know there's a criminal connotation to looting. But if you look at the image on the other side where there are two people who appear to be white, it says two residents wade through chest-deep water after finding bread and soda from a local grocery store in New Orleans, Louisiana. Now, I don't know anything about the writer or writers who wrote these articles, but both of these images show people in desperate situation trying to attain apparently life-sustaining things. I don't see either one of these images carrying a TV, but to the image that appears to be African-American, the conduct is ascribed as criminal. But to the two that appear to be white, the conduct is attributed as innocent conduct. And I think we see this throughout. Go to the next slide, Kevin, because there's a lot that we do in media that sort of perpetuates some of these stereotypes. These images show individuals who were engaged in similar conduct in the same broad community. And the first, you see that there are 4 African Americans who were arrested for burglary in this place in Iowa. And you see these mugshot photos, which is typical when you look at people who have been arrested for criminal conduct. But down in the bottom, you see 3 University of Iowa wrestlers who were arrested. They're also charged with burglary. But these individuals in the paper are shown with their yearbook photos. I'm sure they were not dressed like this when they went out and committed the burglary. The paper got a lot of flack for the way they showed these people engaged in same conduct. One of them you see is dated March 23rd, 2015. The other is March 24th, 2015, but I believe the conduct occurred on the same day. The paper said there was no bias in our reporting this conduct. They said we just used the best photos that we could find or that we had available in order to depict the arrestees on that day. Well, one of these conforms a stereotype when you look at the African Americans, and the other tends to depict and avoids perpetuating criminal conduct. They were both charged, but when the public sees this, one conforms a stereotype of criminality and the other does not. Go to the next slide. Here I want to show you, this is a case that occurred in my court when I was on the district court. There was a particular morning when I was in court presiding, and there was an African-American man who appeared before me charged with an indictment. The first 7 counts of that indictment, and I'll get to this later because they're transposed in the slides. The first 7 counts of the indictment charged him with being a convicted felon in possession of a firearm. And each firearm was set out in a separate count of the indictment. And the final count, count 8, charged him with a drug crime. After going through the plea colloquy, I determined that his plea was knowing and voluntary, and I accepted his plea and set the case up for sentencing. That afternoon, there was a young white male before me charged in a 2-count indictment. Count 1 charged a violation of stolen weapons. And there were 8 weapons in parentheses. Count 2 charged him with being a convicted felon in possession of a firearm. And in parentheses, it showed 8 firearms. At that point, and I just want to show you this, go to the next slide, Kevin. Okay, this is, and I blocked out the names and the case number so that you can't go back and find these individuals. But this first page of the second indictment, this is the young white male, and you'll see that it says between on or about January 15, 2010 and January 21, 2010, this person knowingly possessed stolen firearms as follows, and they're listed, all of them are listed right there. Go to the next page of that indictment. And then you'll see count 2 where it charges those same dates, and this person knowingly possessed a firearm. He was a felon who knowingly possessed a firearm that had traveled in interstate commerce. And you'll see again all of the firearms listed there. So now go to the next indictment, and you'll see the charges. But the next indictment, this is in the same division of the federal court. Here you'll see this person charged in count 1 with being a felon in possession of a firearm, and you'll see there's 1 firearm listed, a Taurus 40 caliber. Go to the next page and just keep going, Kevin. That's count 2. That's another weapon. Count 3, another weapon. Count 4, another weapon. Count 5 and 6 and 7, and then you see the drug count at the end. But here, each weapon comprised a separate count, and so when one looks at this person looks like they're much more dangerous than the other individual. And the government was dismissing count 1 of the white male, and he was only pleading to count 2. The interesting thing about this also is that each count at that time of a federal indictment carried a separate, non-waivable $100 special assessment. So the white male would plead guilty and come out with $100 in special assessments, and the African-American male, who has each weapon charged in a separate count, comes out with a total of $800 in special assessments that are non-waivable. And I've often used this case to ask people, if you see a situation where a person has been convicted of 8 counts of being a felon in possession and one who's been convicted of the 1, just think, knowing nothing more, who appears to you to be the more dangerous? And they said, well, of course, the one with the 8. And so again, it sort of perpetuates that stereotype of dangerousness. But I called the U.S. attorney down and said, okay, tell me why you have this different charging policy. Because in these 2 cases, the only thing I can see that's really different is race. So tell me why there are different charging policies. And we talked a lot about that, but what I did was to use that case, or those 2 cases, to then monitor the conduct and monitor the charging policies. From then on, every time I had a 922G case come through my court, I marked up in the upper left hand of the indictment the race and the gender of the individual charged. And whenever the evaluators came through to talk about how is the prosecutor's office doing, you know, I would talk about and show them these lists of cases, and they could see for themselves whether or not there emerged a pattern of different charging policies. I didn't have to comment on what I thought. I just showed them these piles of cases. But I also talked to the U.S. attorney to say, basically, I am, you know, because as a judge, I'm saying to people that people are treated equally under the law. But I would meet with the prosecutor from time to time and show them this pile of cases, and they could see for themselves whether their assistants were charging differently, and they could have those conversations in which I was not involved. But I would hope that they were as invested as was I in making certain that the community felt that we're not making decisions, disparate decisions based on race. Judge Todd, Chief Holloway, if either one of you have a comment, I'm going to look at the last question that's come in, because I know we only have a few minutes more. If either one of you have anything further you wanted to say, either about that or about our topic. And I'll tell, yes, go ahead. And let me just say, Chief Holloway, I'm going to give you the last question too to add, to talk about as you're going that. The last question is, how can the bad apples in the police department be weeded out? Is there any way to get police officers to violate the blue code and to tell on bad police behavior when they may need that bad apple to protect their back during a police call or other duties on the force? So that's the last question, but comment on anything you want to at this point.
Sure, so I'll start on that one. And that's a cultural thing. And it starts at the top, where the chief or the sheriff, where they tell their people, this is not going to be tolerated. The 8 can't wait that came out, and you're going to find a lot of agencies that are already either state accredited or nationally accredited already have that in their policy for a failure for an officer to report an officer that he or she can both be charged with the same thing or terminated from that. What I want to add on also, Judge Donald, what you're talking about, again, it starts at the top, whether the sheriff or the police chief is having checks and balances in. Our department, we started doing it 2 years ago, maybe, no, I'm sorry, 3 years ago. Every time you make a traffic stop, you have to call out the traffic stop, a reason for the traffic stop before you pull the person over. And then once you clear the traffic stop, you have to tell the reason, whether it's a warning or a ticket, and that's calculated. So every month we get a report on who's doing what. We now, even when the officers brought it up, that now every time you stop a person on the street, you will do the same thing. Show me out with a black male, the reason you're out with that black African-American male or white. So you can start, because they may not even know that they are acting this way. There's one way of bringing it to their attention, because maybe they don't know the profiler. So this is a way of saying, look, this past week you stopped 8 African Americans and you only stopped 1 white, and you work in a white community. Let's see what's going on. So I think that, like you're doing, it's time to, like, say, have those conversations, put something put some type of auditing system in place so you can see it, and that way you can recognize it and you can move on. We're all biased, but recognize what you're doing and then correct that behavior.
Judge Todd.
I will just say, yes, I would say, Judge, that, you know, the question is why does any of this matter? Why does it matter about police and people feeling like they're being treated equally? Well, it's obvious, but when you really delve into it, it's the devil is in the details, as you would say. And so you started out, Judge, by talking about the statistics and how incarceration rates and that sort of thing. We have a mass incarceration crisis in our country and had it for some time. All of this plays into that. You know, the policy, prison policy initiative about 3 or 4 years ago put out data wherein it was revealed, probably for the first time in any systematic way, that 5 states in the US have the highest mass incarceration rates in the world. If they were countries alone, they will have higher incarceration rates than countries that we deem as you know, violators of human rights. And so when we talk about how people feel about the police department, how people feel about the justice system, the police are a key part of what we do. We cannot do in the courts anything without what the police do in the criminal context. And so it is imperative that we see this as a part of the bigger mass incarceration conversation, that we see this as a part of the implicit bias conversation, as you brought in, and that we also see this as a conversation about whether we need to make a harder pivot back towards rehabilitative justice, which would include police officers, and away from this Nixonian era war on drugs kind of retributive, you know, system that we are in, and that has caused such a spike in how many people, especially people of color and men of color, have been incarcerated in this country.
Thank you. We have come to the end, and I want to leave people with this thought. You know, Dr. King said the arc of the moral universe is long, but it bends toward justice. And I say that it doesn't bend of its own volition. It only bends because people, men and women, boys and girls of goodwill, apply their hands to the arc and pull and push it in the direction of justice. We in the criminal justice section are involved in an effort to move the arc toward justice. And we invite those of you who are out there who are not members of the American Bar Association in the criminal justice section to please join with us as we march, push, and work toward justice. We are an organization of prosecutors, defense attorneys, judges, professors, police officers, people in probation. We're working to try and get us to an area where justice is fair and equal to all people, and we invite you to join us. I want to thank our panel today for your insightful comments and for you giving your time to join with us in this important conversation. And thank those of you who attended and participated with us. Thank you for your questions. I will turn you now back to the hands of our staff director, Kevin Scruggs.
Thank you, Judge Arnold, and thank you to the panelists and to the audience for your participation today. Please join us next week, Tuesday, October 20th at 3 p.m. Eastern for the next Rule of Law webinar, How the Role, Voice, and Respect of the Judiciary Impacts the Rule of Law. You can find more information about this and other webinars, as well as membership information on the CJS events webpage. Thank you so much.